Hello and welcome to a special show. I'm Siddharth Talia, and over the next few weeks, we at times now will, through discussions like this one, seek to raise awareness about an extremely critical issue that lies at the heart of any successful economy and society. It's the right to preserve and protect creativity, originality, and intellectual property. For a media organization, it's the right to protect its content, the right to ensure that content is shared and distributed with due attribution, and to be compensated for sharing content if it is indeed used for dissemination by a third party. Now, these are accepted norms worldwide, and in India, to protect the rights of content creators, the Parliament, for example, evolved the Copyright Act of 1957. But we also live in an age of disruption. Artificial intelligence, in an age of depleting attention spans, provides information and news in an instant. Type something in a search box on Google, and its AI overviews will summarize it for you in very quick time. ChatGPT, Perplexity, Gemini, you name it, they condense volumes and tomes of information in quick time to flash it within seconds on your screens. Now, this is information aggregation at one level, but it comes at a cost. The cost of the rights of the content creator, of the lyricist, of the composer, of the journalist, or the organization who is the original creator of that story or that content. Let me now put things in perspective. According to Tollbit, a content licensing platform, news sites and blogs receive 96% less referral traffic from AI search engines than from the traditional Google search. Publisher traffic, according to an estimate, is expected to decrease 20 to 60% on average. Now, according to some researchers, 99.7% of readers never click the original site when AI provides a summary. And for publishers, there is an estimated annual revenue loss to the tune of almost 2.3 billion US dollars. The demand is quite simple. If news articles and content, somebody else's original creation for which they actually hold copyright, are indeed being used by AI applications to train large language models to generate responses, it is incumbent upon that AI platform to seek permission for the use of that content and compensate the creator for the use of that content. But that's not happening. What's happening, viewers, is outright copyright infringement. And this is happening all over. The European Publishers Council has filed an antitrust complaint with the European Union against Google over its AI-generated summaries. The Italian Federation of News Publishers have submitted a formal complaint to Italy's communications watchdog, adding that Google's AI overviews amount to being a quote-unquote traffic killer that reduces visibility, discoverability, and advertising revenues. In the United States, there are at least 40 cases involving news publishers or creators with AI companies. The New York Times, for instance, has sued OpenAI and Perplexity for alleged copyright violations. In September last year, Anthropic settled a case with authors with the settlement valued at approximately 1.5 billion US dollars after a ruling had claimed that it had downloaded millions of pirated copies of books to train its chatbot. It's considered to be one of the largest copyright recoveries in recent memory. But here's what AI companies say in their defense. They claim that using all this information and data to train their models is quote-unquote fair use. Their argument is that the responses that AI generates are transformative in that they do not replicate the original work. So the use of somebody else's information or creation of data to provide an analytical response is not copyright infringement. So they claim that they're not copying original work, they're instead establishing statistical patterns or trends that are different from the original work. But legal experts have argued that this may amount to stretching the idea of fair use and negates the economic incentive that is very much part of copyright. In India, engagement between the government and stakeholders is continuing on this extremely contentious matter. And in another related development, but overseas, in May last year, New York Times entered a deal with Amazon, licensing its content to be used in Amazon's AI platforms. News Corp and OpenAI signed a deal in 2024. So the question, therefore, is this actually the balanced road ahead? Let me now take this across to our guests, and we're currently being joined by Mr. Pawan Duggal, cyber law expert, Nikhil Pava, founder of Medianama and digital rights activist. We also have Mr. Ankush Sabharwal, founder and CEO of CO Rover and Bharat GPT. and Mr. Michael Owens, CEO of the US Global Center for Cyber Policy. We're calling this the AI copyright debate. Let me go first and foremost to Mr. Sabharwal, who is in a way an industry representative here. Mr. Sabharwal, how do you see this entire debate evolving? Do you believe that the defense that's now been provided by the likes of OpenAI, among others, that their reliance on original information from other content creators to feed their respective system to generate responses actually amounts to fair use, and that it's quote unquote transformative in nature? It does not amount to copyright infringement. That's their defense. Do you agree with it?
I think I would have two views on it, right?
Okay.
First, of course, we have to see whether this kind of technology is helping society and mankind, and for sure there should be some kind of relaxation to the technology providers, innovators like them and us, right? So, but if you see the content provider, right? So they have to be fairly compensated, right? So not probably while the models are being created, but once they are being used and the model providers or creators, they are making money because someone is using the model means they are making money.
Yes.
Right. So then I think the part of it must go to the content providers. Right. So we always say, hey, it's publicly available data and it's for fair use. But I think it takes a lot to create that publicly available data. I always give an example. If a book is created, yes, it's publicly available for a user to consume or a person to consume. But if you are using it for some other purpose and monetizing it, I think the original copyright holder must be compensated. Not while the technology is being created, model is being created, but when it is being influenced and being used. I think when they make money, they should be giving it back to the content creators. So I'm not sure about the legal part, a lot of debate, but morally, I'm sure must be compensated.
But when that particular data or information is actually being trained into these LLM models, isn't that the point where permission ought to be sought from the original content creators and compensation paid? That's the question that is also, of course, something that's arising as a result of this discussion. Let me, in fact, go across to Mr. Michael Owens as well. Now, Mr. Owens, here's the defense that Perplexity had offered when New York Times decided to take matters to court. And they said in a statement that they released that publishers have been suing new tech companies for 100 years, starting with radio, TV, the internet, social media, and now AI. Fortunately, it's never worked, or we'd all be talking about this by telegraph. So that was a dismissive response in a way from Perplexity, but where do you stand on this entire matter, sir?
As it relates to that, every major content industry has faced this before. If you said from music, when it went to streaming, the outcome and licenses and royalties were not free use. What we're seeing now is $1 billion lawsuits and these settlements that is emerging because creators are demanding compensation for these data sets, is that they're actually powering AI. The path forward, I think, is not trying to stop AI, because I don't think that's a winning solution, but it's about modernizing what we're doing around copyright. So innovation at scale can work alongside these systems that will still pay people who make this work possible. The idea that how AI breaks this model, right? The internet economy was based on a very simple exchange around this, is that platforms send traffic and then publishers monetize that. But AI has completely broken that. Now, I think, as you mentioned before, 69% of news searches end up in 0 clicks. Yes. And publishers are reporting anywhere between 25 to 50% of those revenues that will be tied to that they completely lose. So I think, when AI answers that question directly, when the platforms are able to keep the user's information and the publisher wind up losing, the business model is broken. And I think that laws around the world are going to have to catch up to the pace in which AI has changed the game.
Well, this actually ends up affecting livelihoods, and we represent a media organization, and this is something that would affect us adversely if it continues in an unchecked manner. And that's pretty much the sentiment in the American media as well, in the media the world over, which is why these litigations are continuing to the pace that they are. Let me go across to Mr. Dugal as well. Mr. Dugal, India has the Indian Copyrights Act of 1957. Do you believe that legal framework is currently adequate in order to deal with this particular problem? Because our stand has always been that if you have all these foreign companies operating in India, they need to comply with Indian laws. And therefore, if there are indeed checks in the Copyright Act of 1957, I can cite Section 14, Section 17, about the first owner, etc. There is enough in that particular act to prevent theft of content and direct copyright infringement taking place on the part of some of these AI applications. Where do you stand on these issues?
I'm very clear that India as a nation today is behind the curve. Why? Because it's still not come up with any dedicated law on artificial intelligence yet. If you're expecting the Information Technology Act 2000 to come to your rescue, then you're mistaken, because this 26-year-old legislation was never drafted keeping in mind artificial intelligence. Having said that, while that's up to the political will of the government, and the government is looking in that direction, the second option is, let's look at what we currently have and then try to enforce the same.
Sure.
Please realize that today it's not just the world of territorial sovereignty, it is also the world of artificial intelligence sovereignty, which means your AI programs may be located anywhere in the world.
True.
But you will, if they are being made available on computers and mobiles located within the country, within our country, then it will have to ensure compliance with the applicable national laws.
Absolutely.
Because that's a logical corollary. But the problem is now it's a wild, wild west. Most of these AI companies are saying, I'm based in America. I'm governed by Section 230 of the Communications Decency Act. It grants me complete immunity. So take it or leave it, I'm not going to comply with your local laws. It's here, I think, that the political will needs to come in. We need to come up with strong messaging to say, look, you may or may not have offices in India.
Correct.
But you will have to comply with Indian law because your output is impacting the cognitive thought process and capabilities of Indians.
Yes.
Further, the said output is available on computers and mobiles located in India, having a direct impact upon lives in India. And that being so, you have to ensure compliance. That being so, the third option, which is that you already have the Copyright Act.
Yes.
And that means that you should ensure compliance with the provisions of Copyright Act, which is a logical corollary. But then please realize that the Copyright Act was never drafted keeping in mind newly emerging technologies like artificial intelligence.
Absolutely. It's about 69 years old.
Its foundational principles and fulcrums are still, its foundational principles and fulcrums are still relevant today.
100%.
The copyright law does not allow you to steal my copyrighted work,
Yes.
use it the way you want to use it, get monies out of it, and I'm left high and dry. That's something that's fundamentally not acceptable to copyright law.
The copyright law also has a clause for fair dealing, which is the equivalent of fair use in some of the other overseas jurisdictions. Can AI companies claim an exception under the fair dealing clause to get away with what they're doing right now? A legal question.
Well, legally speaking, fair use and fair dealing are pretty much well-defined concepts.
Yes.
You cannot land up doing something which actually benefits you from a commercial standpoint and yet argue that this is part of fair use or fair dealing. If it is for genuine criticism, analysis, examination purposes, commenting purposes, academic research, no problem.
Sure.
But the moment you use the copyrighted work of a copyright owner for the purposes of going ahead and generating monies, even if you put your own elements therein, nonetheless, it still is impacting prejudicially the generation of revenues by the copyright owner. And that being so, under the copyright law, you are required to compensate the copyright owner.
Absolutely.
And therefore, the arguing that because AI is a new transformational technology,
Yes.
the existing law will not apply is a legal argument that may not stand.
Absolutely. Let me go across to Mr. Pava. Mr. Pava, there have been licensing agreements that have also been signed between media organizations, and I'm talking specifically about the United States, between media organizations and AI applications or the companies that own these AI applications. I can cite the New York Times and Amazon, for example, or News Corp and OpenAI, News Corp as well as Meta. Is that actually the road ahead, where there is an agreement that's been signed between an AI service and the news organization, a fee that is given, a compensation that is paid for the use of that content? Is that the balanced road ahead, sir?
No, I think there needs to be a fee and a compensation, but it needs to be determined by the two parties involved and not a government, forced standardized fee where you take first and then pay later, which is what the Copyright Committee of the DPIIT seems to be recommending. See, we need to understand over here what these models have done is that they've taken away data from the public domain on the internet, from the public or internet, and then tokenized it in a manner that it is now permanent as a part of their large language models, right? So it is permanent stealing of this information, because publicly available does not mean that it is public domain for anyone to take. What these models also do is that they use a mechanism called retrieval augmentation, a RAG model that is used to improve their outputs with fresh and relevant information, which means that something goes on the web, it will come to your site, it will come to my site, take information live so that it replaces what we provide to our readers immediately. So there is substitution that's taking place without compensation. What is happening is that the cost of production of this information is being externalized to me, to you at Times Now, and to all other media companies. And the benefit is being taken by the model that is taking from us without paying us. And so that cannot be allowed to stand, whatever the Copyright Act even says. I would say that on principle, you need to prevent this theft from happening, because otherwise, look at what's going to happen. If media companies don't get compensated for their work, then they're not going to be able to pay salaries, produce more work. Then who will AI steal from? So in order, and it is in public interest to make sure that reporting happens on things as they happen live. Otherwise, you will have the internet full of misinformation. I mean, someone's gone to court and said that if you don't allow AI companies to take this copyrighted material, then there will be misinformation and AI models will be wrong. But who's going to pay the people who are providing the correct information in the first place, right? Absolutely. The other thing that happens is that the internet, the way it operates, is that publishers monetize both their archives as well as the new information.
Correct.
The archives have already been stolen without compensation. So effectively, the monetization that's only there for new information remains very limited. And so publishers are struggling from a revenue perspective there as well. I mean, Mr. Sabharwal said that payment should be done once the content is used. But my point is, once the content is tokenized, it's impossible to even find its source. Provenance happens at the time of training, not after it's tokenized. So, how do you actually identify where that content is coming from? It's like you've made the atta and you're trying to figure out where the gehu came from, right? Where the wheat came from.
Absolutely.
The last thing I want to just quickly add over here is that we shouldn't be waiting for these companies to first make money and then pay people. And if they've taken our content without our permission, they need to compensate it. How they make money is their problem. How we make money is ours. And so therefore we shouldn't be they shouldn't be allowed to take it from us without compensating for us for it in the first place.
I'm with you on this 100%, Mr. Pava. When a particular AI application is using your information to train the data, the compensation ought not to be paid once that data has been used as an output. It should be paid at the time that the information is actually procured from the company itself. And there needs to be permission sought for that information to be procured and a due compensation paid. That's point number one. On the point of creating some kind of a third-party behemoth that will decide what the rates of licensing ought to be, you're completely against the idea, and so are a lot of media organizations. There should be a direct party-to-party negotiation about what the content licensing fee ought to be, because ultimately, for media organizations, what matters to them the most is their autonomy over the content that they generate. And therefore, that should not be compromised in any which way.
Can I just add one more point?
Yes.
Until an agreement is reached, none of these models and none of these companies should be allowed to take content, because what is happening is they're taking whatever they want from whoever they want, and then they're going into a negotiation. So this theft has already been taken place. That has already taken place.
Yes.
So they need to first compensate for what they have taken. They need to stop taking. I'll give you one example. Perplexity was being restricted from accessing content from Amazon's services. They actually created a crawler that mimicked a human being in order to still go and get that content. So there is deceit in how things are operating right now. Cloudflare has also struggled to block crawlers from Perplexity because they keep changing shape and form. So the thing is that the intent is to take without compensation in the first place.
Mr. Owens, what's your assessment of how big tech is actually being held to account in the United States in particular? They've reached party-to-party licensing agreements in a few cases, so that appears to be a positive sign. But how do you see the road ahead?
I think that this, again, is a very complex, and I appreciate all of what's been brought to the forefront today. There's a part of me that at the U.S. Global Center for Cyber Policy, we look at policy not just from a legal perspective, but also where trends and patterns are going. And to go back to truly understand how AI systems work in LLM training, and the discussion around fair use is a good one here. And I'm just playing devil's advocate for a minute here, just for the show, because when you understand how AI works and the training of LLM, that is where a lot of these AI companies want the conversation to go, because they claim under the model that it doesn't store, retrieve full books or images for the simple fact of regurgitating it. It's actually learning the same way you or I would be learning. And it gathers that information and pulls that system together for a system of learning from many books, from many databases of copyright information. So I think part of this becomes, it can't be there's going to be payment when it's earned, but it has to be when it's learned. Now, that's going to be very tricky because most of these LLM systems can gather information and train from information around the world from many different content creators. And I think that is where the challenge is going to be. But that's also where I think these AI companies have the ability to hinge on this phrase of transformative use, right? Which I think from law, it's a totally different understanding of what transformative use is compared to how the millions and millions and billions of articles and individual content that they're pulling to actually learn. So again, this is a new space that I think we're in.
Absolutely.
I don't think current law is really set up to address this.
It's still evolving, but one case does come to mind when Anthropic decided to actually settle with authors to the tune of almost $1.5 billion. What was actually found was that Anthropic had, in its back end, downloaded pirated copies of a lot of these books to eventually generate the information that it did. And that was, of course, a breach of the law for which they eventually had to settle. So therefore, this is still an evolving discussion. But Mr. Sabharwal, one word from you. I know Mr. Pava wants to respond to what Mr. Owens said. But Mr. Sabharwal, I let you have your say for a moment. Please go ahead.
See, so that's what, So see, it's Bharat GPT, we have never taken publicly available data, right? So we have 24 trillion tokens, and it's all where we have the rights and where we have taken the license or the rights from publishers. Where I was saying, at least compensate on the usage, because the bullet has already been fired, right? The people have created the mega models, even the trillion parameter models. So I think now, instead of they stopping it, because as I said, the applications are already helping society. So now at least there should be mechanism, they pay at least for the usage. There are ways to find out. So I think maybe we have to work towards compensating the copyright holders for the usage now.
All right, Mr. Pava, I'll let you have the final say. I know you wanted to respond to what Mr. Owens was saying, and then we'll close the discussion after because we're running short of time. But yes, Mr. Pava.
The other is we need to look at at AI from a very different perspective from humans. Fair use applies to human beings because they're limited by human capacity. AI has power law at its disposal. The scale at which it can read and it can use that information, it may be transformative. But the word here we need to focus on is it is substituting.
Correct.
And so therefore, transformation without substitution means that you've put in your own effort, your own creativity, and that's what human beings do.
Yes.
This is not transformative use, this is substitution.
Okay.
And therefore, when you substitute someone, without paying them.
That's
by
the
taking
bone
things
of
from them to
contention.
meet
That's the bone of
compensation.
contention because OpenAI claims that this is transformation without substitution, but the people opposing OpenAI and all the media organizations that have decided to go to court, not just against OpenAI but other AI applications, say they're essentially replicating content as opposed to coming out with something new or creative with a new expression. So this is an evolving debate. I'm sure we'll be seeing more of our all of our guests more often as we continue deliberating on these extremely contentious issues over the next few weeks as well. But for the time being, we're closing the discussion. Thank you, Mr. Pava. Thank you, Mr. Duggal. Thank you, Mr. Owens, and also Mr. Sabarwal.